These are part-head appeals in the matter of supporting Care Ltd and Prestwick Care on the subject to the department.
Yes, good morning. Thanks.
Good morning. My Lords, there were four questions that I was asked yesterday that I either said I would take instructions or consider overnight. So if I deal with those first. In respect of other cases that may be under appeal, the One Trees Estates case that you've been taken to, there has been an application for permission to appeal in that case, and this court is currently considering a decision on the papers in respect of permission. There's no application for permission to appeal that was made in New Hope or in Tender Care. There is a fourth case which came before this court called Efficiency for Care, where the challenge included the global assessment ground, the argument that there should have been a global assessment. Permission was refused in the High Court, but this court then granted permission for judicial review on the basis of the conflict between Prestwick and Supporting Care. And that case is awaiting a substantive hearing.
In the High Court?
In the High Court.
Thank you.
The second question, my Lord, it was suggested by my Lord Justice Singh that it would be helpful for me to consider the Friends of the Earth judgment. I'm very grateful for the suggestion. I've considered the case, and copies have been handed out if that's useful.
Thank you.
We would agree respectfully that it is a helpful analysis. So the three categories of case, as my Lord indicated yesterday, are first considerations to which regard must be had, considerations to which regard must not be had, but thirdly those which the decision maker may have regard if in his judgment he thinks it right to do so. And I think it's particularly useful in this context to note paragraph 120, which notes that that category is also can be subdivided into first cases where a decision maker doesn't advert at all to a particular consideration in that category, and the Supreme Court said that unless the consideration is obviously material on Wednesbury grounds, the decision is not affected by unlawfulness by not adverting to it. Secondly, a decision maker may turn their mind to a particular consideration in fact, but decide to give it no weight, and that's subject to the normal public law principles of rationality. So we would agree on reflection that is a helpful analysis. We say it's consistent with the approach that I submitted yesterday, and in particular it's consistent with the points of paragraph 56 of One Trees Estates in terms of what the Secretary of State is actually required to do in this context. So, i.e. that although there is a residual discretion, in the absence of a particular reason to exercise it, for a reason that's not already factored into or provided in the guidance, there's no obligation to address or provide reasons for not exercising that residual discretion in individual cases. And that, as in that case, as in One Trees, once you decide that downgrading as an alternative to revocation isn't appropriate, you're not then required to assess the impact of revocation or to give reasons about that. Thirdly, my Lord Justice Baker asked about how the guidance permits the flexibility that the Secretary of State exercises in terms of extending the grace period for workers to find other employment. Having reviewed the guidance, there's nothing that's inconsistent with the guidance in that approach. So if you'll note, page 80 of the supplemental bundle in Prestwick, the page I took you to, it says that normally it's shortened to 60 days. So there's clearly the possibility envisaged there for it to be a different period of time. And in respect of other employers that might want to recruit them, it's page 115, same bundle. There's provision for a sponsor to seek additional certificates of sponsorship at any time, but they need to explain why they need them, so that there's a specific mechanism. I was told this morning that there are other details of things that the Secretary of State can and does do in these circumstances. If the court wants detail about this, we can provide it in writing. But in terms of the question I was asking, the guidance permits.
Yes. I think certainly for the moment, I think that suffices. Thank you.
Okay.
Thank you.
And then fourthly, again, my Lord Justice Baker asked me about paragraphs 38 and 39 of Rajan Knoll, where this court rejected the idea that it was incumbent on the Secretary of State to consider the consequences of revocation and the difference between the guidance as it was then, which referred to exceptional circumstances where you may not revoke, as opposed to the fact that's not mentioned in the current guidance. On reflection, I don't think I need to add to the answer that I gave yesterday, which is that if that was the position under that guidance, that as paragraph 39, you don't need to exercise the discretion even in those circumstances, then that must apply with even greater force now, where the guidance no longer refers to the exceptional. It's simply a residual discretion outside the guidance altogether. But those were the points from yesterday. In respect of Prestwick, to briefly complete my submissions on Prestwick, I largely finished in respect of my submissions, including on fairness. But just on the heightened standard of fairness, can I just make sure my lords have the reference in our skeleton argument? There's paragraphs 47 through to 59. We set out there our analysis of the case law and our submission that the case law is against there being a heightened standard of fairness, both particularly from Gold Care, but also from Rajan Knoll and St Andrews.
Just that last submission, I think the submission made against you has been that the passage you rely on is about a different legal issue,
Yes.
not about procedural fairness, but challenging the substantive merits of a decision. What's your answer to that?
Well, we've set out in the scope, we don't agree with that. We think they're addressing both. They're addressing both the substantive outcome and the process. So in Gold Care, Alison Foster, it's paragraph 36, specifically talks about fairness. We say that's context to what else she says. She sets out the point that I took you to yesterday, that fairness is dependent on the particular context, requires the body in question to be considered, the type of decision, etc. She's clearly thinking about fairness in those observations. Similarly, in Rajan Knoll, it's paragraph 32, the fact that Lord Justice Tomlinson ends that passage by saying that the exercise on which the Secretary of State is engaged involves no fundamental right, but a right contingent upon adherence to the rules. He's talking about the process in that context in our submission, as well as the outcome. And he's in our submission saying that the process that the Secretary of State adopts is one that can reflect the fact there's no fundamental right involved.
Did you say paragraph 36 in Gold Care?
36 of Gold Care. 30.
Thank you.
Yeah.
I have to say I have some difficulty with that as a matter of principle.
Yes.
And this may be relevant to submissions that Mr. Malik is going to make later on this morning. But if you have, say, a purely discretionary decision, like a decision to give somebody British nationality, not because they have a right to it, but because they apply for naturalisation, there's no right, there's no fundamental right, there's no fundamental right to nationality. But you are entitled to be treated fairly, and it may depend on what the ground is. But let's say, for the sake of argument, that the reason why the Secretary of State refuses your application for the benevolent exercise of a discretion is that the Secretary of State considers that you are a mass murderer. And the chap comes along and says, well, actually, you've got the wrong person. That's not me at all. Why wouldn't there be, as a matter of implied duty, a particularly exacting need to make sure that fairness is complied with there. I'm not sure I understand why the analysis that there are no fundamental rights at stake means that you can't have, where the context requires it, rigorous requirements of procedural fairness.
It may be, it all depends on the context.
Yes.
The only submission that I'm making is that in that respect, the more important the matters at stake, the higher the requirements of procedural fairness. So in a case where the right to life, or one of the most fundamental rights, is at stake, there every opportunity to make sure that this decision is fair must be given. In a case where liberty is at stake, so Osborne is an example of the oral hearing being required,
Yes.
because of what's at stake. And you can compare Osborne with Hassett and Price, for example, that came afterwards, which is about prisoner categorisation, where this court said, well, no, you don't read across the same requirements for an oral hearing because it's not the same things at stake for the prisoner.
Yes.
And the more that's at stake, the more the procedural requirements are imposed, or the greater the procedural requirements are imposed.
Yes.
And in this case, because a licence creates no right, because, as I explained at the beginning yesterday, the consequences are limited or restricted, we say that the requirements, the minimum requirements, are less. That's the extent of the submission.
Okay. Right. Well, I understand. Thank you.
And we also, just to mention, for what it's worth, at paragraph 58, we referred to what Lord Justice Arnold said when he refused permission in this case. We don't entirely understand why, when he gave, we understand why he granted permission subsequently because of supporting care, but why he gave permission on the point about the standard of fairness, given his observations in the previous decision. But that's a matter for the weight you give that is a matter for you. The reference is in our skeleton at paragraph 58.
Thank you.
But on the heightened standard of fairness, as yesterday, we do agree that that's not really the issue in this case anyway. But the reason I wanted to just highlight our position on that is that depending on what this court says on that issue, it may be relevant in other cases.
Yes.
But in this case, we agree it's not really the issue that's going to determine whether it was fair. Mm-hmm. Then turning to supporting care,
Yes.
Just by way of introduction and context. So in supporting care, the judge rejected the challenge by supporting care to the Secretary of State's findings on whether the breaches had taken place. You'll see from the judgment that the judge found that the Secretary of State was entitled to find that the certificate of sponsorship issued to Miss Reimer did not match her actual duties, and that the Secretary of State lawfully considered this was a breach of Annex C1S. And for your note, C1S is at 263 of the supplemental bundle. So C1S is a mandatory ground. Simply the role undertaken by the worker you've sponsored does not match the occupation code on the COS or the job description on the COS. So subject to the cross appeal, that's the position. And secondly, he also found that the difference between the duties, so the duties on the certificate and the actual duties, was substantial or significant. And he also accepted that the Secretary of State had lawfully concluded that the breach was deliberate and dishonest, and therefore a breach of C1Z. In C1Z, you have a 264. So that's where the Secretary of State has reasonable grounds to believe that it's a sham or that it's deliberately exaggerated, a deliberately exaggerated or incorrect job description. So there are two mandatory breaches arising from the same factual element. Also in the Secretary of State's favour, the judge found that the process was fair, paragraph 16 to 25 of the judgment, and he found that the Secretary of State had asked the correct question in respect of dishonesty, paragraphs 26 to 35, and that the Secretary of State hadn't misconstrued the guidance or the description of the job in the certificate of sponsorship, nor that the decision in respect of the breach was irrational or lacking reasons. So that's 36 to 44. Just pausing there, so those are the breaches. I leave the cross appeal to others. But factually, it's significant to note that Supporting Care had not chosen to raise any impact about to raise any issue about the impact of revocation before the decision was taken to revoke. So the suspension letter, which is at 56 to 65, I don't need to take you to this in similar terms to the one at Prestwick in terms of what it suggests. This gives them 20 working days to provide their representations, and that's at page 65 of the supplemental bundle. Then the guidance is the same as the guidance I took you to in the context of Prestwick, so C9.11, which is at 254 of the bundle in Supporting Care. So that's the guide, the point that says they're to provide any mitigation. Supporting Care did not make any representations about impact prior to the decision being taken. So their representations, I think it is worth just looking at. It's a 77 supplemental bundle in Supporting Care. We've been through the various allegations of breaches, and then at the end they say that the documents, representations and information thus far will satisfy the Home Office of the organisation's compliance with the sponsor duties, and then in conclusion believe that the documents, information and action plan moving forward constitute full compliance with the duties. Request the second paragraph reinstating the sponsor licence. What it does say, and we say this isn't a representation on impact, but it does say to allow for the organisation to continue to work towards the fundamental role the organisation plays in the lives of over 210 individuals across various London boroughs, has a strong reputation in providing care. The specific issue was raised for the first time in a pre-action letter, which was before the issue of the claim. That's page 95. And you'll see that the heading at page 95, sixth ground, global assessment of all factors. And there it does say that the Secretary of State was required to carry out a global assessment of all factors. It says that the approach of the Secretary of State forces innocent individuals to suffer the consequences of one person's actions, adversely affects the turnover and overall performance of the business, potentially leading to financial difficulties and even the risk of bankruptcy. Such circumstances can have a devastating impact on the livelihoods of the employees, exacerbating their financial and personal hardships. It does not, however, make any specific reference to impact on care in the pre-action letter. So in terms of what was said by Supporting Care, the submission that I make, which goes back to what I said yesterday, is that it's axiomatic or it's inevitable that revocation will affect sponsored employees, even if they are themselves blameless. That is a feature which is clearly anticipated within the guidance. There were no features in either the representation made before the decision or indeed in the pre-action letter that wouldn't be present in any case, that none of them are specific factors which have any degree of exceptionality. But the judge, nevertheless, found in favour of the claimant on what was ground 4, and I took you to paragraph 55 yesterday. the section runs from 45 to 55. 55 is really the essential paragraph. His criticism was that, as I've mentioned, there was, quote, no actual or at least demonstrable engagement with any other consideration, such as the impact of revocation on the 67 workers and their families, the vulnerable individuals under care, or the adverse impact to the claimant and the wider industry. And he said that the Secretary of State was required to do so and had failed to conduct an adequately reasoned global assessment of all relevant considerations. So in respect of the grounds, they are set out in the skeleton. I think it's fair to say that they are variations on a theme. There really is one ground and variations on it. And the ground is essentially encapsulated, I will cover the others, but it's essentially encapsulated in ground one, which is that the judge erred in concluding that where a mandatory ground for revocation was established, that the Secretary of State was required to go on and assess the potential impact of revocation on the business, its employees, those who receive care services in the wider industry, and to provide reasons setting out a proportionality assessment undertaken by reference to these factors. I refer back essentially to what I said in the first hour and a half or so yesterday in respect of the central issue. And in summary, we say that that approach is not consistent with the law. It is inconsistent with the context in which this decision was made. In particular, there is no entitlement to such consideration under the scheme. The scheme doesn't provide for it. Now, I accept, as I accepted yesterday, that the scheme is not necessarily a complete answer to fairness. Just on that point, I should mention, Mr. Malik drew to my attention this morning the first instance decision in New London College. I'll see if he wants to say more about it in his submissions. But it is an example of where the court found that there was unfairness despite the guidance being followed. As I understand that particular case, there should have been an opportunity to comment before the suspension letter for particular reasons. So, and we don't accept that that can happen in some cases. But nevertheless, the guidance doesn't provide for this sort of global assessment to be required. We also say there is a matter of law. It's inconsistent with those principles set out in St Andrews, and with the propositions in both St Andrews and Raj and Knoll. The light trigger, the cynical level of supervision, the fact that it is a black letter decision in effect, and the approach that the courts have taken to this scheme, which recognise the central importance of trust in the sponsor and the fact that the Secretary of State has legitimate reasons to act firmly in the case of any breach that the Secretary of State considers is serious. We also say that the requirement goes directly against what this court said in Raj and Knoll, paragraphs 38-39, and we say that it's directly contrary to, in effect, all other first instance authorities. And as I said, all of the cases since this case have preferred the reasoning of Prestwick over supporting Care. Paragraph 32 of our skeleton, we set out a number of reasons why we say that it's appropriate for that to be the position, including that there isn't a fundamental right for the sponsor that's involved in that decision, that the strict compliance with the guidance is vitally necessary to ensure that there's effective immigration control. That's from Raj and Knoll, with respect to the strictness. That, again, from Raj and Knoll, that the certainty that the scheme relies upon, rather than being broad guidance or discretion. as articulated in a number of the cases, but particularly clearly in Prestwick, that matters such as the commercial viability of the wider industry of healthcare provision are not relevant to the central question, which is whether the Secretary of State can trust this sponsor to comply with the guidance. And fifthly, the relative expertise of the Secretary of State, which is in immigration control, rather than matters of evaluating economic viability of various disparate businesses.
I'm not sure I entirely follow that line of argument, because if the law is that the Secretary of State does have to take into account certain matters, well, I'm afraid that they'll just have to rearrange their administrative arrangements. If you say, take the analogy with the impact on children, the best interest of children. Some time ago, the Supreme Court held, perhaps contrary to what people had previously thought they should do as a matter of practice, that the best interests of children have to be considered in immigration decisions. Now, the Home Office, I would imagine, does not, by way of background, generally have expertise in family matters. But once the law has been stated to be that you do have to take into account the best interest of children, then presumably they simply rearrange their way of doing things to make sure that they did have relevant staff and experience.
I'd accept that point. But in terms of looking at this as to what should be required from the Secretary of State, the starting point is what is the Secretary of State, what powers are these being exercised under? If this is under the general power in respect of immigration and the specific statutory power that enables the granting of the visas, I'm not sure it's Padfield strictly, but the scope of what the Secretary of State is doing is not to do with healthcare. And that's not, it doesn't, as I say, it doesn't mean the Secretary of State cannot have regard to these matters. But it is a relevant feature that that's not really the area of expertise of the Secretary of State. And the extent to which there is a judgment to be made is perhaps best not one to be imposed through this mechanism on the Secretary of State.
Thank you.
So, as such, while there is a, as we said repeatedly, we accept that there is a residual discretion in the absence of a particular reason to exercise it for a reason that's not already factored into or provided for in the guidance. There's no obligation, we say, to address it or to provide reasons for the non-exercise of that discretion in any individual case.
Thank you. Mr. Manknell,
yes.
Eye on the clock, you have 3 minutes.
I probably do it in that. So that's our main ground. Ground two was that the judge failed to take into account the fact that supporting care had not made any submissions on the potential impact on supporting care's business and employees. And I've taken it to show that they didn't. The first time that they did was after the proceedings were issued, when they provided the various statements in July 2023. But the language of the judgment, particularly paragraph 55, where he talks about a failure to engage, appears to suggest that the judge approached it as if they had done. And that's the simple point there. So we say, regardless of anything else, that was also an error. Ground three, I don't really add very much to what's in the skeleton argument. So that he erred in finding the Secretary of State had failed to consider the impact, because the letter does, in a similar way to Prestwick, makes clear that consideration was given to downgrading, but because of the seriousness of the non-compliance, it was not appropriate. So there's no reason to doubt that the Secretary of State did do what she said she did in the letter. And then ground four, my Lord, I think I can finish in time by saying that we don't really have anything to add to what's in our skeleton argument. That's in respect of the materiality of the reasons. And we say, well, given the lack of basis for why there should have been any exercise of the residual discretion, and the category of the Friends of the Earth case that we would put the nature of this consideration in, any failure to provide reasons isn't material. That there's no need to provide reasons. And providing reasons therefore the non-exercise of this type of discretion would not make any difference in this case. Lords, those are my submissions.
Thank you very much. May I check?
Thank you.
Thank you. Study.
My Lord, because I had the opportunity to consider this overnight, and because I want to make efficient use of my time, I'm not going to adopt perhaps what's the traditional approach of just following my learned friend's submissions through, answering them one by one. I'm going to take submissions slightly out of order in relation to his, so I can address some of the more important issues first in case I run out of time. In that context, the starting point, the first thing I want to address is the distinction, my Lord, highlighted between mandatory considerations and discretionary considerations. Now, to put that in context, we implicitly recognise that. We probably should have expressly recognised that, because at times, my Lord will remember when addressing fairness, I said, made this point, and it is a point I re-emphasise. We say these are mandatory considerations, but even if that's wrong, the Secretary of State has decided in her discretion to take account of these factors, and that still, we say, gives rise to a duty of fairness. So it was implicit in that. But what we thought assists, particularly in light of the fact that in one sense, Friends of the Earth focuses on the assumption that there is a statutory discretion in issue, that it might be worth just going to Volume 2, 738, the New London College judgment and the judgment of Lord Sumption, because of what it says about the way in which this scheme it operates, or the legal basis for this scheme is actually a more accurate way of putting that.
Yes.
And having reflected on it, paragraph 29, we think assists in relation to that.
Could you just give me the page number?
That's 738.
Thank you.
And one way in which it assists is it, in one sense, recognises.
Just forgive me, Mr. Study. Just for a moment. I think this is a very important passage.
Yes.
Thank you.
And speaking for myself, Mr. Study, in case it helps anyone in the courtroom, I've been reading this again overnight, and I think that there's a passage just before the one you're about to cite, at the bottom of page 737.
Yes.
The last 3 lines of 737 going into the following page, I think, are very important. As I read it, Lord Sumption locates the power to do what is going on in this context in the Immigration Act 1971.
Yes.
He's saying it is the statutory power of the Secretary of State to administer the system of immigration control must necessarily extend to a range of ancillary and incidental administrative powers not expressly spelt out in the Act, including the vetting of sponsors.
Yes.
But in my terminology, that is saying what we're dealing with here is an implied statutory power.
Well, I would go. The reason why I've, in one sense, focused on paragraph 29 is.
I'm not stopping you going to paragraph.
No. But can I just put it in context in what I was about to say? It wasn't really to disagree with what my lord was putting to me. It was to say that the complication in this context is that, in one sense, one has a sort of gradation of legal restrictions, in one sense, or legal powers of the Secretary of State. So you start with the Immigration Act, and this is what paragraph 29 in our case recognises. You start with the Immigration Act. You then have, under the Immigration Act, the immigration rules, and then you have beneath that guidance issued by the Secretary of State, and that guidance has to be consistent with the Act. But because it is guidance, it has to be consistent with the rules, which is expressly said in the middle of paragraph 29. It has to be consistent with fundamental legal rights as recognised there. Now, the overall scheme was held to be consistent with those. But it's important to note as well, because it's clear at paragraph 30, Lord Sumption wasn't saying there aren't necessarily details that violate those standards, because he left open the issue of whether or not fees were compatible, because they didn't arise on the facts. And so, that sort of framework, in one sense, and taking it slightly out of order, we also drew attention to not only accept the relevance, obviously, of Friends of the Earth, but we drew attention to the Samuel Smith judgment.
Yes.
And the point that obviously comes from the Samuel Smith judgment.
You have a hard copy of it.
We do have hard copies of that, sorry, my lord. And while we're doing that, we'll hand up the Law Society judgment as well, because I'll make a little bit of a reference to that. Probably more copies than you need, but the top is the Law Society and the bottom is, yes, I think that's the right way. The top is, and the bottom is Sam Smith, or the other way around.
Yeah.
But the obvious point we make from that, because it's very much in tune, we would say, with the it's very much in tune with Friends of the Earth, but it makes the point that, unsurprisingly, given the role policy plays in domestic law, that an obligation to consider something can arise as a matter of policy.
Yes.
Looking at what we say in this case, just to put this in context, we firstly rely on the statutory duties that we say arise under the Healthcare Act and the Care Act. It's wrong in our submission to say that we don't identify particular provisions. In particular, at paragraph 18A of our skeleton argument, we point to section 18 of the Care Act, which is in unqualified terms. We've never produced it. We can put it before the court. We've never done that because it's never really been in dispute that there are duties on local authorities. And we say, in relation to that, well, then if Friends says ECPAT essentially was just a remark in a particular factual context, and what it was saying was it was not hopeless that the government could do something. We say what the judgment actually recognises is that when Parliament enacts a piece of legislation that imposes a duty on a public body, it plainly intends that duty to be carried out. And that is something that all public bodies need to take account of, because clearly other public bodies have the potential to frustrate that. And that's in one sense where One Search fits in. We recognise that One Search is a relatively extreme situation, which is why we didn't sort of allege a breach of the One Search situation. But what One Search demonstrates is that in extreme circumstances, one public authority can frustrate the ability of another public authority to carry out its duties. And that's why we say this need to consider impact on care in particular is a mandatory consideration, because this is guidance. The duty, effectively, to consider it arises from a different statute. It arises from the statutes governing care. If we're wrong about that, going back to New London College, as we made clear, immigration rules also can effectively identify, because they are, to use the perhaps inaccurate language I use, a higher force of, they're higher in the hierarchy. And the purpose of the immigration rules we submit in this context, and I mentioned in passing, I think it's the paragraph in our skeleton argument, I didn't put that in my notes, so I can't remember them, but we set out the background to the immigration rules in this case, and in part they're clearly intended to facilitate the provision of care, indicating this is a relevant factor. Thirdly, we do, as we put it, there is an issue of fundamental rights, given the evidence, which hasn't been contested, about potential impact on life expectancy. And if all of that is wrong, we do submit there would be a rationality issue in terms of failing to consider these the sort of issues that arise in relation to impact. Clearly, the whole objective, in one sense, of immigration legislation, certainly the 1971 Act, is that immigration is controlled in the public interest, and there is an obvious public interest in ensuring care is maintained. But even if we're wrong in relation to that, the terms of the Secretary of State's letter, which hasn't in any way been suggested to be wrong, is that we will always consider impact. Now, going back to Friends of the Earth, that doesn't mean that impact on a particular case will be given no weight. It doesn't necessarily mean that impact will be given no weight in a lot of cases, but it is still a statement of how the Secretary of State approaches matters. And if that's right in our submission, going back to the origin of the guidance quite clearly is a form of policy. It's the fact that this isn't published in the same way in the guidance doesn't change the fact that the statement "we will always consider impact" is policy. And so it still becomes, in our submission, a consideration that the Secretary of State has to take account of, because that's the Secretary of State's policy. And if all of that is wrong, then we still say, because the Secretary of State has indicated they will consider the issue, the fairness issues arise. And that's where we draw, and to be clear, we're not saying we're not suddenly raising an overnight irrationality point by pointing out Law Society. But what we are saying is that the context in which fairness arises, essentially, is the Secretary of State saying, we will consider impact. What Law Society demonstrates, the second limb of the irrationality challenge in that context, is there is a need, essentially, for to avoid, to use that.
Should we look at that?
Yes, sorry, Lord, I'm just trying to go further quickly, but probably too quickly. Law Society is para 98. It's para 98 of the Law Society judgment, the relevant passage, and it distinguishes. It makes clear in our submission, a very helpful way, that there are two aspects to irrationality. Wednesbury, which is obviously well known and the focus of many of the sponsor cases, but the second aspect is what's called methodological error, or what is sort of summarised at the end as being a case where that includes methodological error or logical error. And my Lord, that's in one sense the point why we say, in fact, if the Secretary of State has decided that they need to consider impact, fairness must apply to that, because if you're going to say, as a matter of discretion, we will consider impact, you need to make it clear that is a factor that will be considered, so that people, you know then that you've got the material you need to consider. There is a gap in the reasoning process if you say, well, we'll consider it, and whether you get that material depends on whether the individual happens to think, well, maybe it's worth submitting the material on impact. Your decision-making potentially becomes dependent on whether the individual thinks, well, despite what is said in the guidance, despite what is said in the letter, I need to submit this material. And that's where you have a problem. If once you say you're going to take account of it, in our submission, you need to take account of it. You need to give someone an opportunity, rather, to influence you.
You may be right about that, but I'm not sure that you get that from paragraph 98. I think where it says logical or methodological error, what that's getting at is that if you say 2 + 2 = 5, that's clearly irrational. That's just illogical. But it's got nothing to do with procedural fairness, that paragraph.
Well, my Lord, except the and maybe I should have brought the second ECPAC judgment thinking about it. That's an example of an application of it, because what happened in the second ECPAC judgment was that the Secretary of State essentially said, I'm going to rely on a particular mechanism to deal with the problem of hotels, and then didn't set up a process that allowed the Secretary of State to assess whether the mechanism used was going to be adequate. And that methodological error is in the context of what's described as process irrationality. And the analogy I'm drawing is that if you're going to say, I am going to consider X, you need to have a fair procedure in relation to X, because otherwise you don't know whether actually you've got the material relevant to X. And that's I suppose all I'm saying is that, maybe it's not, I suppose I can make that point without reference to the Law Society in one sense, but that's the point I'm making in relation to it.
Yeah. Well, I understand the argument, and we will consider it on its merits.
Yeah. I understand.
There it is.
Yeah, thank you, my lord. Now, whether or not, in fact, just having made the point I made about the Secretary of State agreeing to consider impact, obviously there was a degree of inconsistency in my learned friend's submissions in relation to that, because at one point, for example, when opening his submissions yesterday afternoon, my learned friend said there is a residual discretion, but it doesn't accept, it's open essentially to say, for the Secretary of State to say, well, the impact on the community is such that the Secretary of State won't revoke. Now, that seems to us very difficult to fit with the letter. And it's also, in one sense, unclear what factor could be of greater significance in exercising a direct discretion other than impact. I mean, my learned friend sort of slightly struggled with respect to him when, I think it was my Lord Justice Baker, put to him the extreme impact of, for example, COVID.
Yes.
And all of this goes to the point, which is in one sense at the heart. And at one point, my learned friend sort of backtracked and seemed to accept this. The issue in this case is not really, which in one sense, as I say, was the Friends of the Earth case, what weight should be given to impact. It's whether, in the first place, impact is a factor that the Secretary of State either is obliged to consider or has agreed to consider. And on the face of it, the letter says the Secretary of State has done that. And in fact, in one sense, even if the threshold is a very high one, if the Secretary of State will almost always discount impact, one of the points that's made, I won't take you to it, because I took you to it yesterday, in the passage of the judgment in New Hope by David Piewski, King's Counsel, he makes the point, in actual fact, the higher the threshold you need to overcome, that in one sense, the more important fairness is, because you need the sort of best opportunity to address that threshold. Turning then to my learned friend's reliance on Raj and Knoll to say these are not considerations. Can I take you to Raj and Knoll, paragraph 38 and 39, because in our submission it simply isn't on point. It's effectively a reasons challenge. Sorry, it's 1081, the relevant passage. It's paragraph 38 and 39. Now, to remind you of the context of this, there was no procedural fairness challenge. There couldn't have been a procedural fairness challenge because clearly the claimant in that case understood there was discretion, put forward representations in relation to it. The issue essentially was, in circumstances where the representations were thin, to use a neutral word, and circumstances where they expressly didn't raise the sort of factors that were raised in the policy, was there a need to expressly address in the decision the matters raised? And you see that in our submission from the first sentence of paragraph 38. The respondent failed to demonstrate in her decision that she'd considered the exercise of her discretion. So it's effectively a reasons point. It then goes on essentially as a matter of fact to find that the sorts of issues raised were simply not sufficient to engage the policy. But it's certainly not dealing with the issue raised here. are these factors that the Secretary of State needed to consider? Because the Secretary of State's implicit case was well, the Secretary of State had clearly had the material before the Secretary of State. The Secretary of State had then rejected it without reasons. And that is much closer to the Friends of the Earth position. Because it's not saying they weren't relevant factors. It just, whether or not you, once you've engaged with them, decided to give them no weight, you needed to set that out in reasoning. Now, my learned friend says the need to take account of impact, and in particular impact on care, is not practicable. But once the Secretary of State accepts, essentially, as they do in the refusal letter, that impact needs to be considered, that implies the Secretary of State will listen to what's being said about impact. The Secretary of State may decide not to give it any weight because the material's not compelling or whatever, but that's a different issue. I don't think I need to deal with the Raj and Noel point in this context about fairness and what is said about rights, and I'm not going to deal with that. What I do want to emphasise that, or just draw attention to in one sense, is because it goes to the point I've just been making about even if it's a discretionary point, but it's one that will be considered, it needs to be drawn attention. One needs to draw attention to it. Because I did wonder about providing ex parte 5, but this court's reviewed that relatively recently in Baligieri. If you go to Bundle 1 of the authorities, page 143, you'll see paragraph 49 and 50, the analysis of Baligieri, which, sorry, not Baligieri, ex parte Fide, and you'll see there, in the judgment of Lord Justice Underhill,
it's a judgment of the court.
It's a judgment of the court, sorry, my lord. Sorry, no, I can understand.
I spotted it as well as my lord.
Yes, I understand the importance of these things, but I'm sorry. It was a quick. I suddenly realised because my Lord Justice Singh's judgments are cited at length through it, and I knew it wasn't my Lord's judgment, but I suddenly thought I'd mention who it was and made the fatal mistake of just flicking to the front and not looking carefully enough. But my Lord, the critical point about that is that even though in one sense the statute made it clear that character was an issue, to fairly, and in one sense, one could say that Mr. Fide was in a better position because he could put forward positive character evidence or whatever. Fairness required him to understand the particular issues that were going to be considered. And in this case, in our submission, that's not the case. The letter, I'm not going to go back to it, if read fairly, we say, makes it clear what was primarily being asked for, what was exclusively being asked for on a fair reading, was a response to the issues raised. And they were all about the breaches. The guidance, just to run through it, firstly makes it clear, as my learned friend says, accepts, that the factors in issue in this case, the primary factors in issue in this case, it's true there were some discretionary factors, were mandatory. That implies the only issue is whether there are breaches. My learned friend hasn't explained why mitigation can't be read in the way we've read it, and we submit that's the critical question to the court. I'll come back to that. And that also needs to be read with the letter. You can't read these documents in isolation because, in one sense, the letter, that one can say that the guidance is in relatively general terms, and the letter adds colour to that. Now, my learned friend says in relation to the argument fairness has to be subjective. That cuts across the guidance. It doesn't in our submission. It merely means that the guidance must be sufficiently clear to ensure the procedure is fair, or indeed that can be done in the letter. My learned friend also points to the fact that the appellant submitted material after the decision, but of course the appellant submitted material after the decision because at that point it was clear impact was going to be taken into consideration. Now, my learned friend says, essentially, once you've signed up to the scheme, you can't then complain, essentially, if the process follows the guidance, because the guidance, you signed up to the scheme. In our submission, the scheme doesn't in any way permit or authorise a breach of common law fairness. As my learned friend fairly accepted this morning, that was the approach in New Hope. New Hope wasn't simply about whether there'd been compliance with the guidance. It's clear, I won't take you to it because I took you to it yesterday, paragraph 105 makes it clear there was separate consideration of common law fairness.
In New Hope. In
New Hope, yes. I think the page reference is page 682.
Thank you.
Now, my Lord pointed out, and this is true, there's been no challenge to the guidance. But of course, the guidance doesn't say, for example, I mean, the guidance is neutral on this, that the letter couldn't say, we will consider impact. And if the letter had said that, there wouldn't be a problem here with fairness. And the problem with the challenge to the policy is, and I haven't brought it, but my Lord will be familiar with it, AR and what the Supreme Court says in relation to that, which it says, effectively, if the policy can be read compatibly with its obligations, there's not a problem here. And the policy doesn't say we're not going to apply common law fairness. It doesn't say we're not going to alert you to the need to consider impact. Now, my learned friend took you to Goldcare and the statement there of the factors that need to be considered.
Mr. Sully, can I just remind you that you've got 5 minutes?
I have, my Lord, and that's why I started also with the... I mean, in one sense, this is dealing more with the detail. Actually, I'm going to move on from Goldcare. Now, my learned friend just going back to the decision letter, my learned friend said in relation to the decision letter, remember one tree, Secretary of State will listen to what you have to say, and that's what the letter was saying. In our submission, in fact, if the Secretary of State is going to make it clear we'll consider anything, the letter needs to make that clear. That's not what happened in this case. Finally, in terms of the procedure, my learned friend says the consequences are obvious, relying on New Hope Care. In our submission, they aren't, because you have a distinction, for example, between situation in this case where the evidence subsequently provided by Gateshead shows a particular impact on a local authority and perhaps more narrow things. In relation to Thameside, my learned friend says, well, Thameside only applies to what's ever in the guidance. Ultimately, we say, in relation to Thameside must apply to any factor that the Secretary of State regards as relevant. That may be where the Law Society case comes more directly into play. My learned friend also says that the Secretary of State had contact with the Department of Health. The point about that is there was no contact with the people most directly affected, which were the appellant and the local authorities. My learned friend pointed in relation to Prestwick to the multiple grounds for revocation, but as I focused in opening on the two mandatory grounds, because there were two mandatory grounds, I didn't go to the discretionary grounds, in part because they were discretionary. Two final points arising from questions of my Lord Justice Baker. My Lord asked about the number of sponsors, and we asked overnight, unsurprisingly, we've not had an answer to this, about how many were in the care sector in the relevant local authority.
I was going to come back at some point about the stats, just to make sure that I got it right.
Yeah.
I was going to actually bother Mr. Hill with that.
But in one sense, the critical thing isn't sort of how many sponsors there are, it's how many vacancies there are in the local authority. And to be fair, two things I'd say fundamentally about that point. One, in terms of impact, although we rely on impact on employees, our fundamental point is about impact on care. Secondly, what we say about that, just to draw your attention to it, is page 207 of the supplementary bundle, paragraph 53. And Ms. Cora very fairly recognises that a number of employees will potentially obtain work, but says we submit, consistent with common sense, that is not necessarily the case, and in any event, it's likely to be.
Which paragraph?
53. It actually starts over the page, actually, at 206.
Yes, thank you.
And she makes the point about disruption. And of course, remember, if the policy is applied, in this case it hasn't been applied for various reasons, but if the policy is applied, you have 60 days to get a job, and that may be out of the country. So, our point is, there's going to be disruption to employees, but it's not necessarily the case that everyone will be have to leave the UK. And and the figures in our submission don't change that. Finally, my Lord, there was some discussion, I think prompted by a question by my Lord, Lord Justice Baker, about the flexibility in the guidance in relation to revocation of leave. We don't dispute the fact that there is that flexibility. Our point in relation to that, though, is that even if that's going to be considered, you need to make you need to firstly know about impact, but secondly, if it's recognised that there is the potential for disruption to care, that doesn't mean that extending the leave is necessarily the answer in every case. And so you need it's further evidence in our submission of what doesn't actually appear to be in dispute, that disrupting the immigration service status of workers, preventing new workers being recruited from overseas, has the potential to have an impact on care. And that's really the point from our point of view. Can I just, I think I've got half a minute. Can I just turn around to make sure I've got no... Yeah. Yes. Sorry, my learner junior wanted me to double check that our basic point in relation to Raj and Noel was it's fact specific. It was what was on the facts, but I think I did that. Yeah.
We have that point. My Lord has a question.
Were you going to make any further submissions in response to what Mr. Maxwell said about mitigation and the way that was used in the letter?
It's in the policy, my Lord.
Policy.
I sort of thought I did, but to be clear, I may need to be clearer then about what I was saying. My starting point in relation to that is simply looking at the word. My learned friend did not explain why mitigation cannot be read in the way we say it can be read. And if we're right about the need for this to be a subjective approach, in other words, what matters is how it was read, unless it's an unreasonable reading, and we accept it, an unreasonable reading, then that is sufficient for us. But secondly, that reference to mitigation also has to be read with the letter, because that's the package essentially that was before the claimant. And when read with the letter, and the letter's focus on the allegations, that supports our interpretation of mitigation. And then when read also with the fact that two of the grounds were mandatory, which on the face of it means, on the face of the policy means no discretion, again, that supports a narrow interpretation of the word mitigation, all of which means it's not unreasonable to have that reading. And we say, because fairness is all about the opportunity to read, you need to be clear if you're going to give someone an opportunity to respond. So I hope, my Lord, that summarises my position in relation to that.
Thank you very much. Yes.
Thank you.
Yes, thank you. Mr. Mallet.
Sorry.
Yeah.
Lords, my learned friend for the Secretary of State told the court yesterday, in an answer to a question by my Lord Justice Baker, and it seemed to his Lordship's surprise that there are over 100,000 sponsors in the UK and some 11,000 in the care sector. It is relevant to recall in my respectful submission that admission of skilled migrants to work here and issuing of licenses for that purpose is not an act of grace. It is not the case that the Secretary of State is being generous and giving skilled migrants and these businesses a favor by issuing licenses. An employer may only employ a skilled migrant if their job appears on the shortage occupation list in the immigration rules, now renamed as Appendix Skilled Occupation. My lords, the list comprises those roles that are deemed by the UK government to be short in supply within the local labour market. An employee may only qualify if their job appears on that list and they earn a salary at a particular level. So the key objective of the scheme, my lords, is to protect and enhance the UK economy and to fill the gap in the market in certain sectors. Now, one of such sectors is the care sector. And on the evidence before the court, there is a significant shortage of care providers in the UK. The fact, my lords, is that there are not enough care workers and providers in this country. SCL is a large care provider seeking to fill the gap. As my lords may have picked from the papers, it has 192 employees and it provides services to hundreds of vulnerable and elderly individuals across London through the NHS and various local authorities. It needed a license to operate. It cannot provide services without the benefit of overseas skilled migrants. And the revocation of that license, of course, triggered these proceedings. Lords, it's right and fair to acknowledge that the Secretary of State is acting in good faith and pursuant to an entirely legitimate aim. She is required to ensure that local employers do not abuse the system. There is room for abuse, and there are individuals and entities looking to cheat and undermine proper immigration control. The sponsors have a duty to cooperate with the Secretary of State and to play their role in maintenance of immigration control. And nothing that I say seeks to underplay that duty and the essential need to identify those who are a threat to immigration control. My lords may have picked from the papers that the sole reason given by the Secretary of State for revoking SCL's license concerns the issue of genuine vacancy. As I mentioned, SCL has a workforce of 192 employees. It had 162 employees at the relevant time. 68 out of those were skilled migrants. One of them is Miss Rima, a senior care worker and a skilled migrant who obtained leave to remain following SCL's decision to assign her a certificate of sponsorship. The Secretary of State is not satisfied that her role of a senior care worker represented a genuine vacancy because what the Secretary of State says she's doing does not match with the description on the certificate. My lords, the judge below granted the judicial review claim on the ground concerning the global assessment, or as my learned friend Mr. Sadi puts it, the impact. And the Secretary of State's appeal is directed to that ground. And what I propose to do, my lords, is to address you on that appeal first, and to seek to persuade you that the judge below made no error of law in granting the judicial review claim. Subject, of course, to any observations, I will then make submissions on my 3 additional grounds. My first additional ground concerns procedural unfairness. The second additional ground concerns failure to ask the correct question and making relevant findings. And the third additional ground concerns misinterpretation of the policy and irrationality. My lords, my learned friend for the Secretary of State refers to these additional grounds as a cross appeal. But may I respectfully make it clear at once that there is no cross appeal before the court?
No, there isn't.
Yeah. I'm not seeking to challenge the judge's order. I'm not asking the court to vary that order. The appeal or cross appeal is against the order as opposed to the judgment.
Yeah, now we understand your position is that the order of the High Court should be upheld, if necessary, for 3 additional reasons.
Yes. Yes, so dealing with the Secretary of State's appeal first. My Lords, you've heard detailed submissions from my learned friend Mr. Sadi as to the law relevant to that point. And I respectfully adopt those submissions and invite the court to accept them. Those submissions apply to my case with equal cogency. My Lord Justice Singh asked a question yesterday as to the source of the power to issue and revoke sponsor licenses. My Lord observed that the question as to what is relevant depends on the source of the power that is being exercised. If I've understood the Secretary of State's position correctly, at one point my learned friend suggested that it was pursuant to some general administrative powers that the Secretary of State has. Well, that, with respect, is not the case. So when the Secretary of State is issuing a license to a sponsor or revoking the license, the Secretary of State is exercising a statutory power, the power under the Immigration Act 1971. The authority for that proposition is the judgment of the Supreme Court in Munir and in New London College. My Lords, you have already seen the judgment in New London College. Of course, you have seen paragraphs 29 and 30. May I just respectfully take my Lords to another paragraph in the judgment?
Just one small point. Do you agree with my provisional view that
Absolutely.
the last sentence of paragraph 28
Yes.
is important?
Yes. So, in New London College, the licenses issued to the 2 colleges were revoked. They issued judicial review proceedings and argued that the revocation was unlawful because it wasn't sanctioned by the statute. Now, the Secretary of State made the same argument that my learned friend sought to make yesterday, namely that the issuing of licenses and revoking the licenses is pursuant to pursuant to some general administrative powers as opposed to the statute. Now that argument was rejected in my respectful submission in clear terms in the judgment itself. So New London College is page 724 of the bundle. And my Lord is absolutely right with respect that what is crucial is what appears at the end of page 737, that it is the power under the Act that the Secretary of State exercises in relation to licenses.
Yeah.
And
it's not an express power.
No.
And therefore it must be an implied power.
Yes. And of course, my Lord, you have seen that paragraph and paragraph 29 to which Mr. Sadi took you to, but it may also assist to see the judgment of Lord Conworth.
Right.
Lord Conworth agrees with what Lord Sumption said, and his judgment is at paragraph 33 onwards. But if you look at paragraph 34, so he summarizes the submission that the Secretary of State made in that case, and the Secretary of State submitted that there was some alternative, unidentified source of the power that isn't in the statute, and that submission was rejected, Lord Conworth says, by Lord Sumption, and Lord Conworth agrees with that approach. And then Lord Conworth summarizes what Lord Sumption has said at paragraph 35. The point essentially is that it's the power under the statute that is being exercised.
But then Lord Conworth goes on to say, I find this more difficult to accept.
Yes. Yes, but if you read on, and Lord, if you look at paragraph 37,
Yes.
so he links the bar to section 1(4) of the 1971 Act and section 3(2)
Exactly.
of the 1971 Act.
Yeah. So although there may be differences in the reasoning of Lord Sumption and Lord Carnworth, your submission is that in substance they are both saying that what's in play here is an implied statutory power.
Yes,
Under the Act,
under the Act, absolutely.
which is what Lord Carmel says in terms,
Yes.
first sentence of paragraph 37.
Yes. Now, the reasoning is based on what the Supreme Court had said earlier in the case of Munir. Lord Justice Singh dealt with the implications of Munir in a case called Anwar in 20.
As usual, I can't remember any of it.
2017. I mean, I have copies of that judgment. I wasn't seeking to place particular reliance on it, but given that my Lord has, in that judgment, dealt with the Immigration Act 1971 and powers of the Secretary of State, sort of residual powers of the Secretary of State, it may be a judgment that my Lord would wish to
Well,
look at.
speaking for myself at the moment, at least, I don't think we need
Okay.
yet more
Thank
authorities
you.
provided, but
Yes.
it's very helpful to see Lord Carnworth's judgment.
Yes, I'm grateful. So I respectfully invite my lords to test the argument that my learned friend for the Secretary of State makes by reference to the power to grant leave to remain or to revoke or cancel or curtail leave to remain. Now, the power to grant leave to remain or revoke leave to remain is a statutory power under the 1971 Act. The Secretary of State makes immigration rules setting out her practice to be followed in the exercise of that discretion. Now, there are provisions in the immigration rules that say that leave will be granted if certain conditions are met, or leave may be granted if certain conditions are met. Likewise, there are provisions in the immigration rules saying that leave will be cancelled, curtailed, or revoked if certain circumstances arise, or leave may be cancelled, curtailed, or revoked in certain circumstances. But no one has ever suggested, my lords, that that is conclusive of the Secretary of State's powers under the 1971 Act. So take the example of an international student. So this is the case of Anwar that my Lord Justice Singh dealt with a few years ago. So an international student is in a typical case not allowed to work in excess of 20 hours per week, but it happens from time to time that a student would breach that condition. He or she would work 21 hours or 22 hours. So notwithstanding what the rules say, it is always open to that student to say to the Secretary of State when the breach is identified that, well, I'm sorry, there was a mix-up, I did not realize that I was breaching the relevant conditions, or I'm just about to complete my course of study. I've invested years of my life funds into studies, so just allow me to finish my course, irrespective of what the rules say. And the Secretary of State would consider exercising residual discretion. The content of the immigration rules, in my respective submission, are comparable with the contents of the policy documents that you have seen. So precisely in the same way, in my respectful submission, the policy itself does not conclusively identify relevant considerations. Now, so far as the facts of SCL are concerned, if the court wishes to see the evidence of impact in my case, it is set out in the witness statement of Mr. Abu Tahir, who is a registered social worker and the head of SCL. And his witness statement starts at page 110 of the supplementary bundle.
Sorry, page.
Page 110 of the supplementary bundle in SCL.
Yes,
So, my lords will see that this is a detailed witness statement, and the evidence as to the impact is summarized, is set out at paragraphs 35 to 60 of this witness statement. My lords will, of course, read the witness statement in due course, but there are four matters, just to summarize the evidence, there are four matters in which Mr. Abu Tahir gives evidence. The first matter, my lords, is the impact on elderly and vulnerable individuals. If a care worker is providing care to an elderly or vulnerable individual, what usually happens is that they develop a strong relationship of trust and confidence. So it's quite a challenge to abruptly change a care worker. It causes significant distress to those who are vulnerable and elderly. The second point that is made concerns the impact on the business, services, and the sector. The business cannot operate without overseas workers. There is already a shortage of local care providers and workers. The business provides invaluable services to the community, and they will not be able to fulfill their various contracts if they do not employ overseas workers. The third point, the impact on skilled migrants. There are 67 or 68 skilled migrants. They're entirely innocent of any wrongdoing. They will be required to leave the country unless, of course, they qualify on some other basis or switch to another employer. And fourth and final point that is made concerns the issue taken by the Secretary of State. My Lord, the sole issue, as I said, concerns one employee out of the workforce of 192. SCL fully cooperated with the Secretary of State, provided catalogue of documents to show that they are reliable sponsors. The Secretary of State takes issue with nothing apart from Ms. Rima. So for the reasons given by my learned friend Mr. Sadi, these are all, in my respective submission, relevant considerations. Now, I entirely accept, as Mr. Sadi accepted, that these matters do not amount to a trump card in SCL's favour. The public interest in immigration control carries significant weight, but there is a public law obligation to engage with these matters and to consider them, and then decide whether the most draconian penalty of immediate revocation is justified. And in exercising that function, informing that view, the Secretary of State will, of course, attach weight to the public interest in immigration control. When the Secretary of State concludes that a business has breached a license condition, she has a range of options available to her. She can disregard the breach. She can provide formal advice to the business. She can issue a warning. She can issue a reprimand. She can issue an action plan requiring particular action to be taken immediately or within a particular time. She can restrict the sponsor's ability to employ more skilled migrants. She can suspend the license as a sanction for a particular period. She can downgrade the license. She can revoke the license, but say that the revocation will take effect, say, in 3 months or 6 months' time, to enable the business to make arrangements for the transition. Or she can revoke the license with immediate effect. So impact, in my respective submission, is relevant when deciding which of these 10 different courses of action is appropriate. So there must be a global assessment of all relevant facts before the Secretary of State decides what action to take out of the range of options that are available to her. Miller and Friend for the Secretary of State submits that SCL made no submissions to the Secretary of State as to the impact. And there was no obligation, therefore, for the Secretary of State to consider it. Now, there are two answers that I seek to put forward in response to that submission. First, my lord, that the points as to the impact were patently obvious. They are not new points and were brought to the Secretary of State's attention before the revocation decision was taken. The second point, my lord, is that SCL was not asked and should have been asked to make submissions on the issue of impact and discretion. It was only invited to make submissions on compliance. Now, so far as the second point is concerned, my lords, I respectfully adopt the submissions that were made by Mr. Sadi, and I do not propose to add anything to what he has said. But I will address you very briefly as to the first point. My lords will recall that Miller and Friend for the Secretary of State took you to the submissions that SCL made following the suspension decision before the revocation decision was taken. Lord, may I take you to those submissions again, just to show you parts of those submissions that were not highlighted by Miller and Friend. So those submissions are at page 66 of the supplementary bundle in SCL's case. Now, if you look at the first page, you'll see a heading, background. Under that heading, SCL says that it provides personal care to people living in their homes. Services are provided to older people and younger disabled adults. And the company is supporting around 200 people in various local authorities. Now, if you then go to page 68 of the bundle, given that we are at this document, may I just ask my lords to just take a note as to what is said in the third paragraph at page 68. It's not relevant to this ground, but it may become relevant in relation to my additional grounds. So you'll see that the point as to Ms. Rima is dealt with. And what was said was that, well, she's a senior care worker. She has skills. She's trained to work. She has completed a particular course, and there's a reference to a statement prepared by Ms. Rima, and it was said that, well, she's actually performing the tasks as set out in the CUS. Just looking at the next page, the question of impact and the services that SCL is providing, page 69, second paragraph, you will see that it was said that the SCL was established in 2010. There were 162 employees at the time. And there is a reference to the shortage occupation list, and that the positions are difficult to fill and were placed on the shortage occupation list to address the problems in the health and care sector. Then at the end of page 69, final paragraph, the organization works with local council and the NHS Trust to support vulnerable people. Without these roles, the organization would be unable to support the 210 people currently being cared by the organization and its employees, some of whom are extremely vulnerable. So it's not the case in my respectful submission that these matters were not identified in the submissions that were made to the Secretary of State before the revocation decision. And then you have the conclusion that appears at page 77, the paragraph that Milena took you to. So the 4 points that I summarized as to the impact from the witness statement of Mr. Abu Tahir were not in truth new points. They were made to the Secretary of State in response to the suspension decision. Can I then show you the revocation decision as to how the Secretary of State dealt with those points? And the revocation decision is in SCL's core bundle at page 214. I'll come back to the first part of this decision when I will address you on the additional grounds. But so far as the Secretary of State's appeal is concerned, may I ask you respectfully to go to page 227 and see paragraphs 80 and 81. This, the Secretary of State says, is an adequate consideration of those matters. But in my respectful submission, it isn't. It's a template, and what is absolutely clear is that the Secretary of State is effectively copying and pasting the paragraphs in every single revocation.
Same wording as in the Prestwick letter.
Exactly the same wording. And I will give you 4 examples where exactly the same wording appears. So what is absolutely clear in my submission is that the Secretary of State is not even applying her mind to the issue of discretion and the impact, but rather uses a template, as the judge below pointed out. So I ask you respectfully to take a note of the wording that appears at 80 and 81.
So can I just interrupt you there for a moment? That submission may be well-founded. We should have to consider that. But the mere fact that a decision maker uses standard wording,
Yes.
doesn't, as a matter of logic, mean that they haven't applied their mind to that particular case. I mean, I think judges sometimes use standard wording.
Yes. Yes, I'm not, my lords. I'm not seeking to persuade my lords that the decision is unlawful because the same wording appears in other cases, but just seeking to highlight, as the judge below pointed out, and the judge in the New Hope Care pointed out, this isn't a case where the Secretary of State has sort of provided any evidence from the decision maker itself. There are no notes of the decision-making process that have been disclosed. There is no witness statement. There's nothing to indicate whether the submissions that were made to the Secretary of State have actually been considered.
But why should we infer that they have not been? They were put to the Secretary of State. Isn't there a presumption of regularity unless you can demonstrate with some evidence that something has gone wrong? And also they do say we always take into consideration the potential impact revocation may have on a sponsor.
Yep.
And indeed, if I can add to that, paragraph 3 on page 214, they say we have considered your representations. That's all they say.
Yes.
They do say they have done it.
Yes, so two short points that I respectfully make in reply. The first point is that the Secretary of State says, this is paragraph 80, that, well, they always take into consideration potential impact of revocation. They are not saying that, at least at paragraphs 80 and 81, that we have actually considered the points as to the impact that were made in the submissions that you made to us. And the second point, my lord, is that if you look at paragraph 82 of this decision, you'll see, after making those general points, the Secretary of State says that, well, downgrading is not appropriate because you have acted in contravention of NXC1S and Z and NXC2B. Now, the point about NXC2B was a bad point. It was abandoned by the Secretary of State subsequently. So NXC2B requires yes, NXC2B, if you wish to see the wording, is at paragraph 56 of this decision, that the license will normally be revoked if the Secretary of State is not satisfied that a business is using process or procedure necessary to fully comply with the sponsorship duties. So the reason why the Secretary of State said she wouldn't consider downgrading the license in my respective submission was because the Secretary of State had identified 3 breaches. Now, the first 2 breaches essentially related to the issue of genuine vacancy, but the third breach, which was subsequently abandoned, concerned a different point.
That wasn't a mandatory.
It wasn't, no.
It was a normally revoked.
Yes. But just for the purpose...
I mean, going back to my point about paragraph 3,
Yes.
what is said, why shouldn't that be read as indicating that the Secretary of State has considered your representations, including the ones which you've carefully taken us to just now?
Lord, may I, just to answer that question, just show you what the judge below said about that point. This is page 112 of the bundle. Paragraph 53, this is a paragraph that my lords have looked at.
Sorry, paragraph 53.
Paragraph 53, yes.
Yeah.
So the judge concludes that there is lack of sufficient clarity in respect of the decision-making process that took place. It's not enough for the Secretary of State to make a general passing comment that she always considers the impact. The Secretary of State is required to engage with the facts of a particular case and then decide whether the ultimate penalty of immediate revocation is justified. So this is at the end of paragraph 53, yes. And then paragraph 55.
Yeah. I mean, we've got to decide whether the judge is correct in
Yes.
that analysis.
Yes,
But I think at the moment, I may have misunderstood, at the moment I think we're just on a precursor to that, excuse me, that more fundamental submission which you're going to make. At the moment, we're just considering whether, as a matter of fact, did the Secretary of State take into account everything that was said in your representations? Now, they have said at paragraph 3, they did.
Yes.
And we have no evidence to contradict that. And you correctly and fairly have accepted that you don't suggest bad faith on the part of the Secretary of State. So,
Yes.
So why should we do anything other than simply proceed on the factual basis that they did consider everything that was said in your representations, which you very helpfully showed us a moment ago? What they were then required to do with that may well be the subject of dispute, which we have to resolve.
Yes. No, the submission, my lord, is that when it comes to the actual consideration of the submissions that were made, that consideration is at paragraphs 80 and 81.
Yes.
And what the Secretary of State there says that, well, we always take into account the potential impact. Now, rather than, in my respectful submission, considering in a reasoned manner as to the impact in this particular case. Yes. So there isn't, in my respectful submission, a reasoned engagement with matters that, in my respectful submission, were relevant. So that is how I put my case. And then, my Lord, the linked point, of course, is that what has happened at paragraphs 80 and 81 is that the Secretary of State said that, well, we always consider the potential impact, and we have considered the possibility of downgrading your license. Well, that is one of the 10 options that were available to the Secretary of State. So no real engagement, in my respectful submission, with the relevant matters. Now, just to, conscious of the time, just to give you some references of other cases where exactly the same wording appears. So you have seen the decision in the linked case. It is in the court bundle in the linked case at page 316, and the paragraphs are 95 to 96.
Of the judgment, of the letter.
Of the letter, yes. New Hope Care case, you have seen the judgment. The relevant paragraph in that judgment is paragraph 14. It's page 667 of the authorities bundle, volume 1. And Lords will see that exactly the same wording appears in that case.
Volume 2, actually.
Volume 2.
667, you say?
Yes. Yes. Then my lords were taken to the judgment in One Trees Care case, and the relevant paragraph there is paragraph 7. This is page 820 of the authorities bundle.
Going back to Due Hope, without interrupting you too much, I hope.
Yes.
Did the deputy judge in that case consider the specific submission, or a submission akin to the one you're making now?
Yes, and my lord was taken to the relevant passage.
I'd forgotten the representation in that case. I've now reminded myself.
Yeah. Yes, so it's towards the end of that judgment. Look at paragraph 127 in particular.
Yes.
Page 687. The judge there said that, well, there is a meaningful distinction between the defendant being required to stand back from the detail of the analysis of the misconduct and ask whether the ultimate sanction of revocation is appropriate in all the circumstances.
Is it 128?
Uh,
I see that you
yes.
you talked about generic language. Is that where we are?
Yes.
Yes.
But of course, you of course consider 127 in particular. Now, so far as paragraphs 1 to 7 relies on the judgment in Prestwick for the reasons that my learned friend Mr. Sadi gives, it's wrong. And I think my learned friend for the Secretary of State also submits that, well, 127 is wrong insofar as it seeks to create a distinction.
Well, 128, are you going to say anything about the way the Deputy Judge dealt with the submission in that case?
Yes, so the judge essentially said that the defendant can be taken to be aware of the relevant of the impact, and those considerations would apply to any decision. Yes.
I'm sorry to interrupt you. Yeah. Forgive me, Mr. Mayor. Before that, he deals with the language point.
Yes. Yes.
Really making the point I was making earlier.
Yes.
The fact that a public authority uses the same wording in different decisions does not lead to the inference that a legally adequate thought process leading to the use of that language has not occurred in this case.
Yes. So, Lord, do not disagree with that. I'm not seeking to submit that, well, the decision is unlawful simply because the same wording is used elsewhere. Yeah. But I just felt that it was appropriate to just flag that, well, that's how these decisions are written. And these two paragraphs appear in every single case that is before you.
And I apologize again for interrupting you, but you were going on to make a point about the last two sentences in that paragraph.
Yes.
That the defendant can be taken to have known, etc.
Yes. I wouldn't disagree that, well, those considerations in principle would apply to this case too. That the defendant, of course, can be taken to be aware of what is happening. That isn't my point. The submission that I make is that when it comes to considering the question of discretion or the impact, there wasn't really a reasoned engagement with the submissions that were made to the Secretary of State. Now, that is, of course, one of the 2 points that I make. Now, following the revocation decision, well, if my lords are against me on this and take the view that, well, there is sort of sufficient engagement with the points that were made in the submissions in the revocation decision, of course, I have a further point, which is the one akin to one that was made by my learned friend Mr. Sadi for the linked appeal. So, following the revocation decision, further evidence is provided. The evidence is in the form of witness statements, further submissions. Of course, I cannot use that evidence to impugn the revocation decision. It postdates that decision. But the submission is that if the Secretary of State had asked SCL to make submissions on the impact, SCL would have provided evidence and made submissions, the sort of submissions and evidence that was subsequently provided. So the fact that, if my lords take the view that there is sufficient engagement with the submissions that SCL made in the revocation decision, that is not, in my respective submission, an answer to the case. There is this further point that is made, and I do respectfully adopt what my learned friend Mr. Sadi said about it.
Can I just ask if, obviously implicit in your particular case is that there was apparently some understanding that impact might have an influence over the decision of the Secretary of State, and therefore it was set out in the letter that you've drawn our attention to, the impact on business, etc. Why was there a duty on the Secretary of State once the decision had been made, as it were, to go back?
Yes.
And seek further information on that particular point? Yes.
So, if my lords, if you look at the submissions that were made to the Secretary of State, the passages that I've shown you, in my respectful submission, were not put forward as a freestanding ground to persuade the Secretary of State to exercise the discretion one way or another. Those points were made under the heading background, just to illustrate what was happening generally with the business. I took you to those submissions simply to show that those are the sort of points that were made in less than clear manner in those submissions. But the real points about impact were made subsequently in the pre-action letter that my learned friend showed you and in the evidence. So the point, my Lord, just to complete the submission, is that SCL was not invited to make submissions on the impact or the question of discussion.
If as the Deputy Judge in New Hope observed, it's obvious, an obvious issue, isn't it something one might expect would be raised in the response? In other words, isn't it something one might expect if you're asked to respond to highlight the impact?
Well, Lord, of course, the suspension decision refers to guidance. The guidance says that, well, if certain circumstances arise, we will revoke the license. So the way in which, in my respective submission, an ordinary license holder reads the letter is to say that, well, you are in breach, address the issue of breach, and if we are not satisfied that you have addressed the issue adequately, we are going to revoke your license. So when considered in that manner, in my respective submission, it wouldn't be obvious to a license holder that it is apt to make submissions on discretion and impact. So the Secretary of State's grounds of appeal, grounds 1, 2, and 3, essentially are these points. Grounds 4 and 5 are on materiality and Section 32(2)A of the Senior Court Act 1981. So I'm not sure if my learned friend is making a sort of freestanding point on materiality and Section 31(2)A. His submission, as I understood it, is that there is no obligation on the Secretary of State to engage with these matters. These are not relevant considerations at all. But I do not understand my learned friend to be arguing that if the court is against him on that point, then this is a case where relief should have been declined in the exercise of discretion or under Section 31(2)A of the Senior Courts Act 1981. But I have addressed the issue of materiality and Section 31(2)A in my skeleton argument at paragraph 32 and 33. This is my replacement skeleton argument.
Mr. Manknell may be able to help us with this, but if I've got the right version of the skeleton argument in front of me, the Secretary of State's skeleton argument in advancing grounds of appeal finishes with ground 4 at paragraph 48.
And that's right, look, we haven't pursued the point on Section 31 here because it wasn't a point that appears to have been taken in front of the judge, and so it seems to me I couldn't say that the judge failed to take it into account appropriately when it wasn't advanced.
That's very helpful, Mr. Manknell, and that is how I had understood your case to be presented.
So, Lord, these are my submissions then on the Secretary of State's appeal.
Could I just go back to the point about we were just discussing about the impact and the submissions made about impact. You took us to various passages this morning. Can I just be clear whether your case is that those were just part of the general background, or whether they were submissions on impact in the response letter?
Well, yeah. So those are part of the general background. So there wasn't, just like the other case, formal submissions to the Secretary of State that if you conclude that there is a breach for X, Y, and Z reason, you should exercise discretion in our favour, and you should not revoke the decision with immediate effect.
Could we just have a look at page 69 of the supplementary bundle? So this is in the middle of your letter, and this is one of the passages you took us to.
Yes.
Now, the passage of page 6, the first entry, go back to 66 that you mentioned, that is under the heading background. But the passages you took us to on page 69 are in response to specific parts of the Secretary of State's suspension notice letter. And so the passages are set out in italics and underlined.
Yes.
On which you then make, or your clients make comment. And the points about the positions being difficult to fill, the pressure on the sector, the working with local councils and NHS trusts to support vulnerable people, the fact that without the rules you'd be unable to support the 210 people, and the points that some of them are extremely vulnerable. Those are in specific, those, as I read it, are specific responses. So could it not be said that you are in fact, your clients were in fact responding, including as part of their response, a response to addressing a range of impact issues?
Yes, Lord, that paragraph you'll see falls under a particular heading which concerns Annex C1Z of the guidance. That paragraph of the guidance concerns the issue of genuine vacancy. Just in fairness to those who settled this letter, I think that is the point that they were addressing. If you look at the first sentence of that particular paragraph, they were essentially saying that, well, the vacancies were genuine. And then they're making a point that they are genuine because we are actually providing care to these individuals, and these are extremely vulnerable. So the submission were made in that context, addressing, in my respectful submission, the issue concerning the breach of the guidance as opposed to a freestanding submission on the issue of discretion. But the reason why I took my lords to these passages was simply to highlight that, well, these points were part of these submissions, but not relevant directly to the issue of discretion or the impact, but generally the points were identified in those submissions.
Can I just ask, if that's right, if this is just background, your criticism of paragraphs 81 and 82 of the decision letter, which is at page 227, that there were effectively inadequate reasons given.
Yes.
And engagement with obviously what had been said. Isn't really your case, therefore, if this is background, that it's not so much inadequate reasons? This should have, in any event, simply prompted the Secretary of State to ask for further evidence about the matters that have been put forward by way of background.
Well, on reflection, perhaps that is a better point to make.
I'm just, it just seems the logic of your argument. This is merely background.
Yes. Yes. Not of course. Not only background, but also SCL's case as to the allegation of breach. So my lord is with respect right that these are the sort of points that were identified in those submissions. Yet there wasn't any invitation to SCL to make any submissions on that question.
Mr. Malik, you've made that submission this morning. I'm getting a bit concerned about whether that is really a respondent's notice point. You may be entitled to make it, but I'm not sure that submission is inviting this court to uphold the reasoning of the judge at paragraph 55.
Yeah, Lord, I do apologise if I appear to have made a new point, but I am inviting my lords to uphold the judge's decision for the reasons given by the judge on this particular point.
At this stage of the argument,
yes,
because you haven't yet moved on to the respondent's notice,
yes,
you invite us to uphold what the judge said,
yes,
essentially at paragraph 55. And just help me with this. Would it be the case that reasoning would equally apply in a case where your clients or somebody in your client's position had not set out the particular facts that you have shown us
yes,
in the representations? Because, as I understand it, what the judge is saying is a proposition of law.
yes,
Which can't, if it's right, it can't, I think, vary according to what happens to be said in a particular case or isn't said. Because he's saying that there is an obligation on the Secretary of State to consider these issues, which he there sets out. And also, we mustn't forget that he does it on the foundation of paragraph 54, where he cites this court's judgment in Balajigari.
yes,
That appears to be the legal foundation for the obligation that he is asserting exists.
yes. So Balajigari is a different case, no doubt about it. But what the judge in my respective submission is really saying in those paragraphs is that the fact that there is a breach is not the end of the matter.
Yeah.
There is a discretion that is available, and the Secretary of State hasn't really lawfully exercised that discretion.
Yes, and you say that he was right to say that.
Yes.
So is that your response to the Secretary of State's appeal? And you're going to turn to the respondent's notice?
Yes. So,
Thank you.
Lord, I'm grateful. So the first additional ground concerns procedural unfairness. My learned friend, Mr. Sadi, made submissions on the case law and took the courts to key authorities, including Osborne, Balajigari, Raj and Noel, etc. And I again respectfully adopt his submissions. But may I take the court to Balajigari to make two additional points, the points that do not arise in Mr. Sadi's case, but do arise in my case. So Balajigari is in volume 1, page 124. My lords, of course, are familiar with the judgment. The Secretary of State accused migrants of dishonesty, refused leave to remain without giving them an opportunity to address the allegation, without communicating the suspicion. And there is a summary of the relevant case law at paragraphs 45 to 48, 49 in particular, includes, of course, the decision in Al-Fayed, the nationality matter that my Lord Justice Singh referred to yesterday. The conclusion, my lord, appears at paragraphs 54 and 55. If you look at 54, it's reference to Al-Fayed that following that judgment, the Secretary of State introduced a minded to refuse procedure under which the applicants were given opportunity to address any concerns that he might have before a decision is taken. And then paragraph 55 is where you'll see, in my respectful submission, the actual conclusion. The Secretary of State is required as a matter of procedural fairness to indicate clearly the first phrase that I would highlight. There must be clear indication, nothing less than an indication with clarity would suffice to the applicant that he has that suspicion, the word that I emphasize again. So the obligation on the Secretary of State is to clearly indicate the suspicion. Now, what the Secretary of State cannot do, and then if you read on that paragraph, my lords, you'll see that the opportunity to make submissions concern not only the allegation of dishonesty, but also the discretion. So what the Secretary of State cannot do to discharge the duty is to make a decision, to make a finding of dishonesty, and to then say to the applicant that, well, I have made that finding. You now persuade me that my finding is wrong.
I'm not sure I'm following the analogy with Balajigari or Al-Fayed. It could be argued that what the Court of Appeal in substance required in Fayed is what the Secretary of State in the present context already does. In other words, you have a minded to state.
Yes.
Because you have the suspension letter.
Yes.
That's your, they say, we haven't made our final minds up yet.
Yeah.
This is an interim decision. You've got 20 days to make your representations. What would you like to say?
Yes.
Right? And that was missing in Fayed. That was the whole point. And so ever since Fayed, that process has been introduced because this court held that it needed to be.
Yeah. So, my lord, if this is what in fact had happened in this case, then that's the end of this additional ground. Right. But I will seek to demonstrate that this is not what has happened here. The Secretary of State, in my respectful submission, made a conclusive finding of dishonesty in the suspension decision.
Oh, I see.
So the minded to refuse procedure wasn't followed.
I see.
Now, my lord will recall, and my Lord Justice Singh will recall that the Secretary of State in Balajigari made an argument that, well, one should look at the scheme as a whole. The Secretary of State alleges, the Secretary of State finds that a person is dishonest, issues a decision, and it is then open to that person to apply for administrative review and to say that, well, here is the further evidence. I'm not dishonest and your original decision was wrong. But that argument was rejected by the court, and you have that test that, well, it is the suspicion or concern that you must identify. And the reasons are at paragraphs 60 and paragraph 60 essentially on the next page. That the ability to make representations after a decision has been taken would be insufficient. Yes. And then, of course, a reference to Sinfield that, well, once a decision is taken and a finding is made, then the decision maker would become unduly fixed, would be defensive as to that finding. So this is what, in my respectful submission, had happened in this case. And I will explain why that is so when I'll show you the decisions.
You said, and a finding is made. You said the decision taken and a finding is made in that submission. Does that say, does this submission extend to findings of dishonesty as well as decisions?
Lord, I'm not sure with respect if there is a difference between a decision as to dishonesty or finding.
Okay, so you mean the decision as to dishonesty?
Yes, so what the Secretary...
No, that's fine, I understand.
So what the Secretary of State should have done the Secretary of State should have put to SCL that I have a suspicion that you're dishonest. These are my concerns. I want you to address those concerns. But what the Secretary of State did here was that the Secretary of State made an unfair finding of dishonesty without putting SCL on notice, without giving the opportunity to make submissions, and then said to SCL, well, this is my finding. You go on and persuade me that I'm wrong. That is inconsistent in my respective submission with the principle. The second point that respectfully make in relation, by reference to Balaji Gari, concerns the interviews. Now, my Lord Justice Singh may recall that one of the 4 appellants in Balaji Gari was interviewed by the Secretary of State before the decision was taken. And the Secretary of State argued that, well, the interview was the opportunity for the applicant to make submissions. May I take my lords to the part of the judgment that deals with that particular matter. Now, if you go to page 164 of the bundle, and if you look at paragraphs 146 and 147, so the Secretary of State interviewed Mr. Kawas before a decision is taken, and the contents of the interview are summarized at paragraph 147. The Secretary of State identified in the interview the discrepancy between the earnings declared to HMRC and the earnings put forward in the application for leave to remain. The applicant sought to put forward an explanation, and then this is paragraph 148. The Secretary of State rejects that explanation and concludes that Mr. Kawas was dishonest. The Secretary of State argued before this court that, well, that was enough to meet the requirement of procedural fairness. This was the opportunity to make submissions. That point was dealt with at page 168 of the bundle. You'll see that, Lords will see that the court felt that that there was an obvious force in that submission. This is page 168 of the bundle, that was the opportunity for the applicant to make submissions.
Which paragraph?
So page 168, paragraph 159 is where you have the submission that the Secretary of State made. And just between letters A and B, the court said that there was force in that submission. But submission was rejected for the reasons given at paragraph 160. And the reasons given at 160 in my respective submission apply to this case too, and to the interviews that were conducted. It wasn't fair, the court said, that Mr. Kawas should have been expected to give a detailed and definitive answers to an accusation of dishonesty without prior notice. So Mr. Kawas wasn't told why he was interviewed. The allegation wasn't, the suspicion wasn't put to him prior to the interview. And the assumption was wrong that Mr. Kawas would have come prepared to face the interview and to give a detailed explanation of the error. And then the court took the view that, well, once that point is reached, the case is indistinguishable from other cases. So the fact that someone was interviewed is not enough. Of course, I make this point because Mr. Abu Tahir and Ms. Rima were both interviewed by the Secretary of State, but they weren't told why they were being interviewed. The suspicion of dishonesty wasn't identified during the interview. They were not told to address that suspicion. So, Lord, this is Balaji Gari. Now, can I then just address you very briefly as to the facts of this case and how these principles ought to be applied? So, you have the interview notes relating to the interview of Ms. Rima and Mr. Abu Tahir in the supplementary bundle at pages 23 to 42. Of course,
Yes.
I will not invite my lords to read the interview now, but what is absolutely clear, my lord, is that the suspicion of dishonesty wasn't identified in the interview, just like Mr. Covers. It cannot be assumed that Mr. Abu Tahir and Ms. Rima would go to the interview prepared to deal with an allegation that they know nothing about. They were not given any opportunity to address the suspicion or the allegation. So the fact that there were interviews does not make the process fair. Now, it can be said that at that point, the Secretary of State had no reason to suspect dishonesty. And it may be that the suspicion arose during the interviews. Well, if that is the case, then during the interview, the suspicion must have been identified, put to Ms. Rima and Mr. Abu Tahir, should be given an opportunity to address the concerns. If not during the interview, then in a follow-up letter or in a further interview. So the point wasn't made in the interview, and immediately and shortly after the interviews, the suspension decision was issued. Now, can I just take you to the suspension decision then? This is at page 56 of this bundle, the supplementary bundle. Page 56, you'll see a heading, General Sponsor Duties. Paragraph 3 is a summary of job description that appears at the certificate of sponsorship. It wasn't, of course, put to Ms. Rima that, well, what she is doing is not entirely consistent with the job duties that appear. But if you look at paragraph 7, this is where the Secretary of State makes a finding. It is clear, the Secretary of State said, that they, Ms. Rima and Ms. Karim, the point about Ms. Karim was later dropped. It is clear that they are not undertaking any senior or supervisory duties. Therefore, we are not satisfied that their roles represent a genuine vacancy. So this isn't, in my respectful submission, a minded to refuse letter. This is a finding, an unfair finding that was made without giving an opportunity to Ms. Rima and Mr. Abu Tahir to address the issue.
Sorry, can I just ask, would it be for Ms. Rima to make that? It's not a suspicion about her personally, is it? It's about the organisation, as I understand it.
No, both I would say, because when I will address you on additional grounds 2 and 3, so if the allegation is that the vacancy is not genuine, it's an allegation of bad faith, so it must mean that, well, the employer, that there isn't a vacancy that exists, it's all a shame. So what cannot happen, of course, is for there to be a vacancy that does not exist without the involvement of the migrant himself or herself. So it's an allegation of bad faith, in my respectful submission, against Ms. Rima and.
Sure, I follow that, Mr. Malik. Why couldn't you, in principle, have a worker who is perfectly honestly doing what they are asked to do by their employer, but the breach of the guidance is found by the Secretary of State to be that the job description does not match what, in fact, that worker is being required to do. So that would be a fault on the part of the employer, not necessarily the worker, I think. Yeah.
Lord, I will, of course, take you to the relevant parts of the guidance.
Okay.
And what guidance actually links that point is with the deliberate wrongdoing. And there are examples within the guidance as to the circumstances in which a vacancy would not be considered as a genuine vacancy. So if the point simply is that there isn't an exact match, then of course it's possible for an employee to work in good faith. But if the allegation is that the vacancy is sham, as was the case here, then it is just inconceivable that the employee wouldn't know about it. So you have the finding at paragraph 7. Now, if you then go to page 64 of the bundle and see the heading next steps, and under that heading, the Secretary of State says if there is any doubt, then that doubt disappears when one looks at paragraph 46. We believe, the Secretary of State says, the issues described above constitute a failure to comply with your duties. Again, not an indication of suspicion or concern, but a finding that there is a breach.
Believe, it's not we find, and I wonder whether perhaps we should look at that in the context of what the next paragraph is.
Yes.
I'm going to emphasise believe in a way which suggests an alternative meaning.
Yes.
We believe the issues described above constitute a failure to comply with your responsibilities, to give you an opportunity to explain the above issues before we begin revocation action. We've suspended, and you have 20 working days to submit, make representations, including submitted evidence, response to the letter, etc. So, could it not be said that, read as a whole, this is equivalent to a minded to letter?
Yes. No is the answer in my respective submission. You look at, in my respective submission, paragraph 7 and paragraph 46. Paragraph 7, the paragraph that I've taken you to, it is clear, not that it's arguable or we suspect that there isn't a genuine vacancy. It's clear, and we are not satisfied that there is a genuine vacancy.
But would it not be, the whole scheme of this is to give the sponsors a chance to respond before they make a revocation decision.
So yeah. So
why does it follow from read it as a whole that it's indicative that the mind is closed and a decision has been taken?
Well, because of paragraph 7 in my respective submission. So what this letter should have said was that, well, we suspect wrongdoing. We have concerns about this issue, but before we make a final decision, this is your opportunity to make submissions. That would be a sort of typical minded to refuse letter that follows in nationality and immigration cases.
And if I may, is dishonesty mentioned in the word dishonesty mentioned expressly or by implication in this letter?
So that is my additional grounds 4 and 5. So the Secretary of State says that she's alleging dishonesty in this letter, and she's alleging dishonesty impliedly, she says.
Yes.
So my submission, of course, is that, well, you cannot simply...
Yes. It's not, the word isn't mentioned.
No. But word deliberate exaggeration, I think, is used, but I'll address you on that.
And genuine vacancies.
Genuine vacancies, yeah.
Right. Yeah. Thank you.
So this, the submission, Lords, is that this isn't a minded to refuse letter. Can I just quickly show you what the judge said about this ground? Judge's judgment is in the core bundle. Page 114 of the core bundle. You'll see a heading, findings. Under that heading, the judge deals with that particular ground. So if you look at paragraph 21, the judge says that the submissions rather missed the mark, and the judge makes the point that, well, the interviews did not take place because of suspicion. And I think the point is that the suspicion arose during the interview. If that is the case, then in my respective submission, the duty to act fairly required the interviewing officer to put that point to Ms. Rima and Mr. Abu Tahir. Well, should have put to them that, well, you have said that you're performing these duties, but that is sort of somewhat different from what appears on your certificate of sponsorship. What is your answer to that? If not that, then there could have been a follow-up interview or a minded to refuse letter. So that is my submission as to paragraph 21. And then paragraph 22, the judge says that, well, they were not asked specific questions about job description, but they were asked sort of general questions about the duties, etc. The answer to that point is in Balaji Gari, the test is clear indication. So nothing less than clear indication would suffice. The Secretary of State is required to clearly indicate the suspicion, not ask sort of general questions and assume that the person who is being interviewed would understand the purpose. And then finally, the final point is made at paragraph 24 that well, there was a suspension decision, and SCL was given an opportunity to make submissions following the suspension decision. The point that, of course, is troubling Lord Justice Baker. The answer to that, again, in my submission, is twofold. The first is that the suspension decision was not, as I said, merely a minded to refuse letter, but a finding. And secondly, this is the same point that the Secretary of State made unsuccessfully in Balaji Gari, that, well, this is my decision. You have a right to apply for administrative review. And although I've made a finding against you, you apply for administrative review, you persuade me that I'm wrong.
I'm not sure that an administrative review after a final decision is really analogous to a suspension notice, which is not yet a final decision and is expressly on the terms that this is your 20-day period to tell us why we're getting it wrong before the decision is finalized.
Well, yes, but if the reason why I draw an analogy, my Lord, is simply to illustrate the point that, well, fairness requires opportunity to be given before a particular finding is made. And the submission is that the suspension decision was actually a finding of wrongdoing.
Right.
My learned friend made a point yesterday, and of course, and then Lord Justice Singh picked that point and made certain observations as to the impact of the guidance. So the Secretary of State says, my learned friend says that, well, the Secretary of State essentially followed the guidance here, suspended the license, gave the opportunity to make submissions. There is no challenge to the guidance, and therefore the decision is lawful and fair. Well, this is a point that was made by the Secretary of State in New London College litigation, and it was flatly rejected at first instance. There wasn't any appeal on that point. Of course, conscious that quite a lot of authorities have been handed up, but if you wish to see the first instance judgment in New London College case, I have copies of that judgment. It deals with this particular point.
I think that would be helpful, because this is a new point, as you say, which hasn't previously been covered.
So that was a case where the Secretary of State made a decision without giving the opportunity, made a suspension decision without giving the opportunity to make submissions. The first ground of challenge was that the decision was procedurally unfair. The Secretary of State made the same point that my learned friend made yesterday. This is paragraph 55 of the judgment. So the Secretary of State submitted that there was no obligation on the Secretary of State to give notice of its allegation and to give the opportunity to make submissions before a decision is taken. The Secretary of State said that they were acting in accordance with the published guidance and the decision was lawful. There is then a discussion of the case law concerning duty to act fairly, the sort of authorities that the court is familiar with, duty in particular. And Mr. Justice Williams concluded that the decision was unfair. The point about the policy was dealt with at paragraph 60. So it's paragraph 60 really, in particular, the last two sentences of paragraph 60. The fact that the Secretary of State has followed the guidance does not mean that the decision is lawful. The content of the duty to act fairly must be judged against the duty principles. Policy or guidance published by UKBA cannot by itself resolve what constitutes the duty one way or another. So the fact that the Secretary of State followed the published policy is not an answer to this ground.
I think we may need to think about that quite carefully, because one of the things that duty says is that one of the things that structures what the content of procedural fairness is in any particular context, it is the framework within which the decision is taken.
Yes.
And although I understand your point that this was not subject to an appeal, it is only a first instance decision
Yes.
with respect, and
Yes.
This court is not bound by it. And,
Yeah.
it's not immediately obvious to me that it's necessarily correct. It may be correct in that context.
Yes.
Because there are lots and lots of administrative contexts where
Yes.
a public authority sets out an express procedure. And I can readily understand the argument, well, that's not necessarily exhaustive of the entirety of fairness. I can understand that argument. But at least as a starting point, it might well be said, well, that's what they've said is required in this particular context. So, for example, it will often be said that we will only consider representations in writing. There will not be an oral hearing. I think that's said in the present context.
Yes.
Now, does that mean that in any individual case, someone can come along and say, well, I should have been given an oral hearing? Or do you have to challenge the policy?
My submission, it would be open to a person to come and argue that failure to have an oral hearing was procedurally unfair on the facts of that particular case.
That may be right, but it's not immediately obvious to me that this is quite a big point potentially of legal principle.
Take the example, of course, of Balajigari litigation. So there is nothing in the immigration rules about minded to refuse procedure. Well, if you're dishonest, the Secretary of State can revoke your leave or refuse your application. Yes. But the court made it absolutely clear that the contents of the immigration rules do not define common law duty to act fairly and introduce the minded to refuse procedure. The same approach, in my respective submission, applies to the guidance. So these are my submissions on additional ground 1.
Yes. Have you come to a convenient pause there?
Yes. So after the lunch break, a short adjournment, I'll address you on additional grounds 2 and 3.
Very good. And you will finish by 2:45.
Yes.
Very good. We look forward to hearing you again at 2 o'clock.
Good.
Courthouse table.